Hello everyone. In this lecture, we will try to understand section 11 of CPC. Section 11 of CPC, it deals with the principle of res judicata. Res judicata. We will try to understand what is the object of res judicata, what is the concept of it, why res judicata is needed, and then we will try to understand what is the difference between res judicata and estoppel and so on. What is constructive res judicata? All this. First of all, let us try to understand what res judicata is all about. A very important topic in CPC. See, the main objective of res judicata is to stop the dispute between parties. For example, let's say A and B are having dispute over a land property. It may be like this, that the court gave the judgment in favor of A. Suppose B went to the court again and made the court aware that there was some sort of mistake while giving the judgment. Then the court again looked into the matter, whether the decision was right or not. Then it may be like this, that the case may turn to B's favor. Then it may be like this, that A again went to the court challenging the decision in favor of B. Then the case may again come in favor of A. So the case will continue like this only. It may be also like this, that B went to the court and filed a case against A. Then the court dismissed it. Then after 2 or 3 months, again let's say A went to the court to file the case against B over another related dispute. Then the court, let's say, again summoned B, called B. The court saw the case and dismissed it again. Then after 5 or 6 months, suppose A again in this manner went to the court and so on. So how long the parties will disturb the court? How long the this precious time of the court will be wasted like this? There should be some sort of end to this. So, keeping all these things in mind, section 11 has been included in the Code of Civil Procedure. That there must be end of litigation. There must be what? End of litigation. Now this res judicata is based upon three substantial maxims. The first maxim of it is Nemo, debet, bis, vexari, pro, una, et eadem, causa. I have given the name of the maxims in the description section. In the description section, I have given the name of the maxims. So don't worry. It simply means this Nemo, debet, bis, vexari, pro, una, et eadem, causa. It simply means no man shall be punished twice for the same offense. It simply means no man shall be punished twice for the same offense. And then the second one, the next maxim, the second one, it is interest Reipublicae ut sit finis Litium. It simply means it is in the interest of the state that there should be an end to litigation, or litigation must come to an end. Litigation must come to an end. Then the third one, the third maxim, the next maxim is res judicata pro veritate Accipitur, which means that a judicial decision must be accepted as correct. A judicial decision must be accepted as correct. So these are having different pronunciations. Don't go for pronunciations, okay? Just go through the description section. I have given the name of the maxim, okay? So don't worry. So these three maxims. These three maxims. So based on these three maxims, the principle of res judicata, the doctrine of res judicata, let's say, is based. So see, now let us try to understand section 11. Let us try to understand section 11. See, in section 11, it has been explained that we have discussed that if there is a dispute and the dispute has been decided by any court of competent jurisdiction, then by taking that particular matter, one cannot file the case again. That is, the subsequent court having competent jurisdiction will not entertain the decided matter. The matter has already been decided. So see, the explanation of it is very important. The explanation of it is very important, of section 11. Its explanation firstly says that the former suit which has been discussed in the section 11, former suit, which means that suit which has been decided at first. See, it doesn't matter here which suit has been filed earlier. It doesn't matter here which suit has been filed earlier. Here what matters is that which suit has been decided at first. That will be regarded as former suit. Then see, the explanation 2, it talks about competence. Explanation 2 says the competency which the court has. That is, how much competent the court is. How much competent the court is to decide the matter. That will be determined. Then comes the former suit. The matter which is present in the former suit, that a party wants to take to another suit for filing a case, whether that matter was raised in the former or the previous suit, whether the other party has accepted or admitted that matter in the previous suit, or whether that matter has been rejected by the other party in the former suit. Or it may be like this, that there was a dispute which could be raised in the previous suit, or was necessary to be raised, but the party filing the subsequent suit did not raise it. It is totally immaterial here, as in the next suit it will be considered that those matters which could be raised, in the former suit will be regarded to be issues in the former suit. So now in the new suit, such matters cannot be included, cannot be raised. This is the meaning of it. Like suppose I am making it a little bit simple. Like suppose there is a bona fide litigant, good faith. There is someone who want to do a litigation on behalf of the society, let's say, with a good purpose. Or suppose there is a person who on behalf of some people wants to do a litigation, filing a suit. Then whatever number of people coming under the suit, whatever number it is there, they all will be regarded as parties under that suit or of that suit. And this res judicata will also be applicable on the execution of decrees and orders. And the last point of it is that, see, if any issue has been decided by a court of limited jurisdiction, if any decision has been decided by a court of limited jurisdiction, it was competent. The court was competent, but there was limited jurisdiction. And the issue has already been decided with the limited jurisdiction of the court. Then these also, as a res judicata, will be applicable, will operate as res judicata. Later on, somebody cannot say like this, that the court which has given the decision had limited jurisdiction, had limitation. It cannot be said like this later on. So this is what section 11 says. Now related to this section 11, let us try to understand some illustrations to make it simple. Suppose, let's say there is a dispute of breach of contract between A and B. Suppose A with malafide intention, bad intention, ill intention. A with malafide intention went to the court, and filed a suit requesting for a court order so that A may get 50,000 rupees from B, because B, as per A, according to A, committed the breach of contract. But the court, let's say, suppose, dismissed the suit. The court observed that there is no ground and gave judgment of the suit in favor of B. Here, the res judicata will be applicable. Here, A again cannot go to the same court or another competent court and file a suit against B, because the court has already given judgment seeing no grounds against B. Now let's say the dispute is about a property will. Suppose A filed a suit against B, C and D. A filed the suit, let's say, to get his own portion of land. A filed the suit. Let's say the court interpreted that will. Explained the will. Now, as the court here explained the will, here what will happen in the future? In the future, if B, C and D do some sort of litigation against A, then the will that has been explained by the court previously, that will become res judicata, which means the interpretation given by the court previously, the interpretation of the will given by the court previously, only that will be considered. So in this way, res judicata will be applicable. If suppose a person went to the High Court, let's say, taking a particular matter through Article 226 of the Indian Constitution, Article 226, and if the High Court dismisses the suit, then for that cause of action, that person cannot move to the Supreme Court through Article 32. And it was also decided in a particular case. The name of the case is Daria versus State of UP. Daria versus State of Uttar Pradesh by Allahabad High Court. A person in Allahabad High Court filed a petition. Then that petition got dismissed there. Then that person went to the Supreme Court, Honorable Supreme Court. And Honorable Supreme Court held the principle of res judicata must be applied here. So Honorable Supreme Court accepted the argument of the opposite party to apply the principle of res judicata in this regard. And Honorable Supreme Court held it cannot be further tried. So one point more can be added here as an example, like let's say, if a person files suit related to property, let's say A filed a suit, let's say A filed a case against B in the court, that the partition done in that property, A should get his portion in the property. Now see, B says, suppose that partition did not happen. What B is saying, that partition did not happen. Suppose the suit came in favor of B. A here afterwards, if wants to file a suit considering what B said in the previous suit, what B said, that no such partition happened, then in this regard A will not be barred. A will not be prevented from filing the suit for partition for getting his own portion of land. Okay. Then let us little bit discuss about constructive res judicata. This is very important. Constructive res judicata. See, res judicata that we have already discussed means where a matter has already been decided. The matter has been already adjudicated, which means the decision has been given based on the issues in the suit. This is very important. Underline issues in the suit. See, when we talk about, this is very important here. See, when we talk about issues, issues are raised when one party asserts one thing and the other party denies that. So see, a conflict gets created. A conflict gets created. This is what issue is all about in law. So when a court decides a particular issue, then the law says that one cannot move to the court taking the same issue, taking the same issues to the court, because issue has already been decided by the court. That issue has already been decided by the court. So the principle of res judicata will be applicable here, which says when an issue has already been decided, when an issue has been already decided by the court, again the same issue cannot be relitigated. But what about those scenarios where one issue could be raised but parties did not raise, raise the issue, did not raise the issue? That the issue could be raised means one party could assert an issue but did not assert, or the defendant could deny an issue showing the grounds but did not deny. That's why we are saying that an issue could be raised but has not been raised. So whether in such cases, while filing the subsequent suit, whether that issue can be raised by any party, whether by plaintiff or defendant, such issue can be raised, whether such issue can be raised that was not raised in the previous suit or the former suit. If we say yes, that it can be allowed, if we say this, since it could not be raised at first in the previous suit, then what will happen in this regard is that the very object of res judicata will get frustrated, will get defeated. See, those maxims upon which the principle of res judicata is based, like there should be an end to litigation, no person shall be punished twice for the same offense, and judicial decision must be accepted as correct, all these principles will be defeated if this thing is allowed in the subsequent suit. So we are creating a legal fiction here. This is very important. We are creating what? A legal fiction. We create a legal construct where we say that those issues which have not been raised, whether you are a defendant or plaintiff in the previous suit, and those issues were in your knowledge, you could raise it easily, but deliberately you did not raise the issue in the previous suit. Or we will presume, the law will presume, it will be presumed by a reasonable person that that fact or issue was in the knowledge of the person. It was in the knowledge of the person. So it will not be allowed in the subsequent suit to raise such issues. It will not be allowed in the subsequent suit to raise such issues, because it will be presumed. There will be presumption of it. It will be presumed in your knowledge it was there, presumed by law. In your knowledge it was there. The issue fact was there in your knowledge and you were supposed to raise it. And the most important thing here to remember, it will be presumed that you have raised the issue in the previous suit. It will be presumed by the law, legal fiction. So this presumption by the law is a legal fiction which will be applicable here. And moreover, it will be presumed that not only you have raised the issue, but the court also has also given decision considering this as one of the issues. But in reality, you did not raise it in the previous suit, despite the fact issue was in your knowledge, but you were supposed to raise it. Now again, this issue cannot be relitigated. So the question is, why we are presuming that you have raised the issue despite the fact you did not raise the issue, but you could raise as it was in your knowledge, and we are also presuming the court has given decision on this issue. Also because for section 11, it is very important that decision must be given on that issue by the court. For section 11, it is very important that decision must be given on that issue by the court. So we will not only presume that it was in your knowledge, but we will also presume that you raised the issue and the court also gave decision on it. Then only the conditions of section 11 gets fulfilled, that the first court already decided that issue. So it will not be allowed to be relitigated. It will not be allowed to be relitigated. The court will not allow. So this is constructive res judicata. A res judicata of legal fiction. And this legal fiction has been given a statutory recognition in explanation 4 of section 11. This legal fiction has been given what? A statutory recognition. This is very important. Where? In explanation 4 of section 11. Which talks about constructive res judicata. Now let us cite one example of res judicata to make it more simple to understand the principle of res judicata based on state of UP versus Nawab Hussain case. State of UP versus Nawab Hussain case. 1977 Supreme Court decision. 1977 Supreme Court decision, State of UP versus Nawab Hussain. In this case, what happened is that a person, Mr. X, filed a suit in the court that in the dismissal order which was issued against him, due procedure had not been complied. Due procedure had not been complied. The court dismissed his Mr. X, the writ petition of Mr. X, his writ petition. The court held that the due procedure had been complied. After this, Mr. X raised an issue in a subsequent suit that since he was appointed by IG, then the dismissal of him done by DIG, that is irregular, as Mr. X raised only IG could dismiss him, as since the appointing authority was IG. Therefore, the compliance of procedure did not happen according to Mr. X. During dismissing Mr. X raised that the due procedure had not been complied. So Mr. X raised that his dismissal must be declared invalid. In the subsequent suit, the contention he had was accepted by the trial court. Appellate court also accepted this. Even the High Court also accepted this. But in the Supreme Court, again, State of UP raised that here constructive res judicata must be applied. So the Supreme Court agreed. The Honorable Supreme Court agreed that constructive res judicata must be applied here. When it was said earlier by Mr. X that due compliance was not done during his dismissal, then it could be raised, because at first Mr. X said that due compliance did not happen because he was not given the time to explain himself. Second time, Mr. X said that due compliance did not happen because as IG was the appointing authority, so only IG could remove or dismiss him. Dismissal authority should be IG, not DIG, according to Mr. X, which was raised in the subsequent suit. So this non-compliance issue, it was there in the knowledge of Mr. X and could be raised in the earlier suit. So the Honorable Supreme Court upheld that it will be presumed that you had this issue in your knowledge, and it will also be presumed you raised it, and the court also considering this gave its decision, and the dismissal has been regarded to be valid. So in the subsequent suit, this issue cannot be raised subsequently because this issue has already been adjudged, and due to this, dismissal of Mr. X is valid. Dismissal of Mr. X is valid and constructive res judicata will be applied here. The Honorable Supreme Court made it clear in this case. Thank you.